Regular agenda item number 1.
Items for individual consideration. Applicants are limited to 15 minutes presentation time with a 5-minute rebuttal if needed. Remaining speakers are limited to 30 total minutes of testimony time with 3 minutes assigned per speaker. The presiding officer may extend these times as deemed necessary. Non-public hearing items. The presiding officer may permit limited public comment for items on the agenda not posted for a public hearing. The presiding officer will establish time limits based upon the number of speaker requests, the length of the agenda, and to ensure meeting efficiency, and may include a cumulative time limit. Speakers will be called in the order the cards are received until the cumulative time is exhausted. Item number 1. Public hearing on an application for the adoption of a municipal setting designation ordinance for the PSC Management LP Plano campus property on a 71.2 acre tract of land located at 2300 West Plano Parkway as requested by Dell Incorporated.
Good evening. My name is Caleb Thornhill, the Director of Engineering. The item before you is a public hearing item. In 2003, the Texas legislature passed a municipal setting designation, or an MSD, a statute which created a new alternative for persons addressing the groundwater contamination. An MSD, or a municipal setting designation, puts deed restraints that prohibit the use of groundwater for potable or drinkable uses. TCUQ has developed a process to apply for an MSD, and we are here tonight as a part of that process. The applicant is here tonight and will give you a brief presentation on the MSD they are applied for.
Good evening. My name is Deborah Baker, and I'm here on behalf of the MSD application filed by PSC. PSC is the current owner of property that we're asking for a deed restriction for the sole reason to make sure no one can use it for drinking water. That's the only issue. Dell used to own PSC, but it has since sold it to another company. But Dell is continuing to remediate the property under a regulatory program. So that is the brief background. I have a PowerPoint that I've been asked to show, but I wanted to take 4 points to just sort of tell you quickly. The property is already in a cleanup program under the TCEQ, our Texas Commission of Environmental Quality. So it's being remediated under a regulatory program supervised by the TCEQ. And this is part of the process. The TCEQ runs it, it's in charge, and they'll dictate how historical impacts will be dealt with. So the property will be remediated. So I just wanted to say that up front, because sometimes the Texas legislature's rules aren't always as clear as we would have written them if we had written them ourselves, and they bear a little explaining. So today, the only issue we're asking here is that the applicant be able to put a deed restriction on its own property. That is the only matter at issue, so that no one, for the health-based reason that no one can drink the water. Everyone here is on city water. We couldn't use this law that the Texas legislature passed if anyone was on groundwater. So they require it to have to be remediating it under TCEQ supervision, have to have city water so no one can access it. So there's no exposure issue here. So I wanted to put that up front and then walk through the slides with you and then take any questions you might have. So thank you. So basically back to, what is an MSD? People say, what does that stand for? It's a municipal setting designation, and it is, in the simplest form, a deed restriction. It is to make sure no future owner, for example, can come in and put a drinking water well where there might be impact. So it is a way to make sure that it doesn't become exposed. It is not exposed now. There's no pathway. But how do you protect that going forward? So the Texas legislature in 2003 developed the law and said if you're on city water and you're in the program remediating property, you can ask the city for a resolution of support to deed restrict your own property. So this is only the applicant's property. It doesn't deed restrict any other property. And what it requires is that it's supervised by the TCEQ. It requires the city to support it. And we have had to do a public hearing to request the ordinance, which occurred last week. Why is an MSD used? I think when people hear it, they think, oh, this is a substitution for the remediation program. It's not. It is just a part of it. It's one step. It's just the deed restriction part. But it protects the public health, again, by making sure no one in the future can access the water. It's not accessible now, but you want to make sure it's not in the future. And it allows properties to move forward if, for example, in urban areas, much of the property, groundwater underneath our urban areas in Houston and Dallas in particular are impacted, gas stations, things like that. Here we have an MSD in Plano. We have one in Richardson that's been done. 336 of them have been done since 2003. And it helps with property being transferred and sold. And the law basically says you can only do it if you have drinking water available at the city. So let me go to showing you where the property is. I don't know if you can see the green line there. That's basically the 71 acres that's been talked about. And where this came from was, and I don't know if any of you remember, but in the 60s, I have a nod, yes, in the 60s, 70s, maybe 80s, a company called Atlantic Richfield Company developed this property. They owned it. They developed it. It was vacant when they acquired it. And they used it for research and some testing. They did some oil field exploration. It's not a lot known back about what they did in the 60s, but this was a property that they developed and used. And the groundwater and other impacts on the property are a result of historical impacts. In 2000, a company called PSC acquired it, and that was actually a Ross Perot company. Some of you are familiar with it, so you know of what I speak. And in 2009, Dell came along and purchased the property. Dell, as you know, it's a computer company. It used the property for office space, data management. So it doesn't manufacture or do operations, didn't have anything to do with the contamination, but acquired it after the fact. And it probably was surprised when they found out that some of the impacts that they didn't know about. But when PSC did discover it, it did take advantage of the voluntary cleanup program, and that's where you self-report to the TCEQ. Even though they didn't do it, they did own the property. They self-reported to this TCEQ, and they've been investigating it and working on with the TCEQ, what are the impacts? How are we going to address that? And that process still continues. But basically, they're remediating historical impacts that were caused by someone else. The groundwater that's impacted is the green line. It is all on site of the property, the ARCO property, with just a little area that has gone off-site. Those landowner properties were notified as well. The TCEQ will deal with all of those, what the law requires, for those types of properties, what kind of cleanup. So where we are is here asking to put a deed restriction only on the PSC property, only to make sure no one can put a drinking water well in inadvertently in the future, perhaps either not knowing that there is an impact to the groundwater. Other impacts to groundwater, this is just about drinking water. You can't drink it. If there are impacts from groundwater to other sources or to the environment, the TCEQ will say how that has to be dealt with. So this is a narrow issue before you, and we met with the public and explained that as well. I think people are always concerned about, impacts near where they are, where they live, but in this case, it is an on-site issue as far as there is no exposure. The property, this soil contamination is on-site. We're trying to deed restrict the groundwater that's on-site. And so we've held the public meeting. We're at the public hearing today, and the next steps, are that we ask that you consider the ordinance. The city engineer, we've worked with them and shown them the information, and they've recommended it. That's our understanding. So I'd be happy to take any questions, but would appreciate, being able to get your support to make sure no one drinks impacted water in the future.
Any questions for the applicant before I open up the public hearing?
I have a question.
Yes, sir.
So in the photo that you showed us where this site is located, there are some great neighborhoods just to the north of this site. So can you just confirm that other than if a neighbor wants to draw, do a water well, which is not going to happen now, but is that neighborhood in danger? Or is there any exposure, any harm
No.
to that neighborhood?
There's no exposure pathway at all.
Okay, and then this is a question for the city, I guess. Are there any water wells within the 5-mile radius?
So there are 2 wells, but they're both abandoned. So there's no active wells in that 5-mile radius.
Okay, thank you.
Councilwoman?
You mentioned that the company voluntarily started working on a process to remediate the situation. What are they doing?
What the TCQ requires is you undertake tests to determine, where impacts might be, and it takes some time. There aren't many records, and you have to look at try to figure out what were the past uses of the property. So they did soil testing and stepped out to figure out where that was there exposure, how far down is it, and then followed up with groundwater testing, did testing to make sure there were no vapors, allowed that were coming out of the soil that could be, an odor issue or exposure issue. So that's the basis of the testing. It's following a program that the TCQ has rules about how you do it, how many tests you do it. It reports monthly to the TCQ, a report on what happened this month, what were the investigations, what is being planned, and that's all public record at the TCEQ.
So if this is passed tonight, those safety precautions will still continue on?
Absolutely.
Any further questions? Yeah, okay. Okay, seeing none, we'll open up the public hearing. Anyone
you.
who'd like to address council on this item?
I do have speakers. The first one is Edward Baxter.
No, please. No worries.
And I appreciate Mr. Kelly. Actually, the neighborhood you speak of is right my house, right there across the street. And we've had that house for 35 years. And now that it's public knowledge, and I have several people here from North Crest, which is right there parallel to Plano Parkway. And I remember Arco Oil across the street. And we'd like to know the impact of our property values and, of course, once the remediation, and I'm a businessman, so I understand I bought a lot of properties in the past, and once it becomes known, our house is, knock on wood, appreciated quite nicely in the last 35 years that we own that property, and I just feel like we need some answers as to what do we, the council and the client, going to do to help the neighborhood to, for the future, see what happens with the possibility of reselling the properties, and et cetera. And, we've been taxpayers for 35 years, and we'd like to know what you guys are going to do to protect our investment. So, I'm not sure. So, I don't know the process, but what do I do now? Answer questions, or do we just move on?
Well, so restate your question, I guess, we're just not.
Excuse me?
Restate your question, please.
The question is, we were under the impression that the company perhaps is going to get and stand behind a little bit closer to protecting possible values for the properties, because once remediation and everything becomes public knowledge, and we, with all due respect to you, ladies and gentlemen, looks like you've known about it for about 8 years or 7 years, so that's news to us. I know I just literally sitting by the pool realized, oh my gosh, there's a little issue going on in our neighborhood. So we're kind of got a little short as far as the notice. And as council and we as taxpayers would like to know, one, what can you and should and can within the law and et cetera do to protect our values and et cetera? What would the client or the property owner is willing to do to, I don't even know the legal, things, to obviously protect our properties, because, and on a side issue, which is a personal issue, I do a lot of gardening, so I have fruit trees and vegetables and other things, and I just need to know, and I have 5 grandkids. And so I need to know, make sure when I feed them my tomatoes and, cucumbers and et cetera, I'm not poisoning them because I have no idea as to what's going on with the water now, so.
Please, no, please
No,
not.
great.
Do not,
I have
do not
4
speak
huge
from-
huskies, and believe me, yes, pets too.
Okay, thank you. Okay, we'll ask some of those questions. Any other speakers? Thank you for your comments.
Tanya Vexer?
Good evening. With all due respect, if you historically look into cases like this, the corporations are always saying these sorts of things, and the homeowners are always at the bad end of the deal. So I respectfully, sorry, I'm very nervous.
It's okay.
Request that you deny their request for now until they do more, something else, like something needs to be looked into our properties to see if our soil does have contamination. And like he was saying, I have a vegetable garden and herb garden that I've been feeding myself and family off of for years. Is this going to affect my health? Am I going to get cancer from the benzene? If we wanted to sell our house, who's going to want to buy a house that's known to have contaminated soil? I doubt any of you would want to. I mean, nobody would want to. So the value could go down. We might not be able to sell our house. Your mission statement talks about quality of life for citizens. So let's keep this in mind here, that we're the citizens, not a corporation. The people are what puts you in office here. Look and think about, what's affecting us, not a company. We are people. I mean, maybe since some of you are, serving limited terms, or all of you actually, you might not care and think about the impact that it's having on us people that, want to live here for the rest of our lives and maybe leave our house that's paid off to our children. I just don't think that they should get a pass from you. You need to put the people first. It needs to be looked into more. They need to test the neighborhood soil. I live right across the street from that. And like I said, I've been eating this stuff. It's really scary. Am I going to get cancer? I mean, if it's in water, what person is going to go dig a well for drinking water at an industrial site or a business site? That's not going to happen. So holding off for a little bit for this is not going to hurt them. Nobody's going to go in there and try to dig a well for drinking water. I mean, I think we can all agree on that. But we live there. We have children, grandchildren, animals. We were growing things. We have fruit trees. All the money that we invested in that, now we don't want to eat it. Who's going to pay for that? Who's going to pay if our property values go down? They should not get a pass right now until more things are looked into. The city should hire some outside sources and have things tested or whatever, and they should be paying for the bill. It doesn't matter who owned it before, they own it now. You can't keep passing the buck. It's not fair. Are you going to lower our taxes since we can't use our vegetable gardens and eat our fruit on our fruit trees? I doubt it. It sounds like you want to raise taxes. Let's remember that their attorneys and their people, this is all about money. And let's not forget that the love of money is the root of all evil. So keep that into consideration and think about the people. Thank you.
Thank you for your comments.
Elizabeth Perry?
Good evening, everyone. Mr. Kelly, again, thank you for complimenting our neighborhood. We're all very fond of it, as you can tell. It is a lovely neighborhood, and unfortunately, it's right across the field from where that facility is. And I attended the meeting last week, as did a few of my neighbors. Sadly, not as big a turnout as I would have liked to have seen, and I think that's in part because we got very short notice about this meeting, and it came packaged in a pretty standard City of Plano letter that I think probably 3/4 of the people in my neighborhood threw away thinking it was junk mail. I opened it up, and I was concerned. I don't know about everybody else in this room, but I saw Aaron Brockovich, right? I saw a civil action. And yes, I am an attorney, and I researched every one of these chemicals the second I read this letter, and it scared the crap out of me. Okay? They want to pass. I sat through their meeting last week, and I asked them some hard questions. Okay? They want you guys to give them this designation that says, hey, you can't drill here. You can't pull the water out of here. Well, trust me, none of us want to pull that water out of there. Our bigger concern is the water is leaching. And one of the persons, who I won't point out specifically, said, well, it's only leached 17 feet since it came to our attention. 17 feet it has moved outside of the actual contained part of the building into the ground surface. And what happens then is water evaporates, gets into the air, becomes vapors, and that concerns me. And I've researched on the EPA websites as well as some other websites, and cancers are very, very strictly associated with each and every one of these chemicals. This scares me. I'm not asking outright that you deny their request, but I'm asking that this be tabled so that we can look into it further. My neighbors have expressed to me, I've reached out on them on a neighborhood app called Nextdoor. I've notified everybody about what was going on, and I got a huge number of response from people saying they wanted to come and they couldn't make it for whatever reason. I've had people reach out to me and ask, can we start a petition to you guys asking that you please not pass this until further research is done? We're talking about our health and our lives and our property value. And we would ask that at this point, this matter be tabled and that we be allowed to bring in some outside folks and have some outside testing, not funded necessarily by you folks, but by those who are concerned about it, so that we can get some true answers and decide how best to handle this matter. Because that's my life and my house, and these are my neighbors.
Thank you.
The last speaker is Robert Miller.
Mr. Mayor, members of the council, my name is Robert Miller. I live at 2300 West Ridge Drive, which is at the corner of West Ridge and Wilson, a couple blocks from here, a couple blocks from this site. We moved into our house in 1978, and as president of the Homeowners Association, I'm just here tonight by myself because we didn't really have time for a meeting. I thought maybe the public meeting we had, there'd be enough people to take a vote, but there weren't. I put the notice out when I got it on our Homeowners Association website, and I always put in there, if you got any questions, send me an email, call me, and I got zip response from anybody. I've listened to the public meeting. I've read the stuff that's been published about this. The impacted water is 40 feet below the surface. If it's going anywhere, it's going to Richardson. It's not going this way. And what people don't seem to understand is this is just one thing that in a process that the TCEQ requires to remediate this stuff. It hasn't blown into our neighborhood. I've been there for that long, and I still got all my fingers, I think. So it's just one thing to do to make it a little safer so that no one drills a water well. Back when we were having our drought, everybody remember our drought? It's history now. Everybody asked about drilling water wells, and I said, well, you could do it, but you won't like the water you get. It's very brackish. It's not good for most anything anyway. And as the city engineer said, there's 2 abandoned wells somewhere in the neighborhood. I don't even know where that is, but we've got a very large development going in next door to this thing, the Rosewood Heritage Creek side. And I know they're aware of this, and they didn't seem to be too concerned about it impacting their $1 billion that they're about to spend on everything. So I think this is something that y'all should support, and I hope you do support it. As far as any property values going down, if they've been reporting to the TCEQ for the last 4 or 5 years, it's already been public information, and my property values haven't gone down. They keep going up because everybody seems to want to move to Plano. So I hope that you are able to look at this, ask any more questions of the people who are here who know this stuff, and approve it. Thank you.
Thank you, Mr. Miller. No more speakers. We'll close the public hearing and confine comments to council. So I guess one thing I want to make sure we clarify, the water supply that we, Caleb, maybe you just verify, the water supply that we use as citizens to drink and to water our yards does not come from that source. It comes from the North Texas Water District, right?
That's correct.
So that is completely independent of what some of the citizens talking about, what they use to water their yard and to drink.
That's correct. Yeah,
Okay.
all of that comes from the district.
Okay. And so the comment, I'm sorry, I missed her name. She talked about the seepage. Can someone speak on that, please? I just want some clarification as to what that means.
Sure. I think what was being referred to is there was a question about, since the historical time when the impacts occurred, has it been migrating? And actually, the answer of out of 30 years or 40 years, it has migrated 17 feet. That's how it got over the property boundary. That was the answer, which actually suggests, and the testing shows degradation chemicals, which means that over 20, 30, 40 years, it breaks down. So the testing shows that it's old and that it's left on its own, will degrade itself and the chemicals will get lesser. But it shows a very, over a long period of time, it had only gotten that far. And then they've stepped out to define the boundary, and that's the end of it. So in actuality, it is a very slow, very historical 13 feet over 40 years that is degrading and is not increasing. So that's the technical answer.
Thank you. And I guess the last question I had, Caleb, is just what we're voting on tonight is to make through this designation to say that we're containing any type of usage of that soil. Did I get that right? Am I getting that right?
Yeah, you're putting an ordinance restriction on that property that it has to use potable water, that it cannot use groundwater as a potable water source.
If someone were on that property, that's all they can use. So tabling it is not going to change. I'm not sure the value of tabling this item because it's not going to change the nature of what we're trying to do here. That's right. Okay. All right. Please.
On this picture with the green outline that you have up, is that the area that you tested? Is that showing the area that was tested, or have you tested outside of those boundaries?
So I'll let our tester answer that question for you. Thank you, Paul. Sure. This is Paul Moore from Zephyr Consultants.
Yes, I'm a hydrogeologist with Zephyr Environmental consulting firm. The boundary was defined by placing monitoring wells across the property. And in order to draw those boundaries, we have to have a well outside that boundary that is less than what the drinking water standard is for that particular chemical of concern. What you're looking at was a combination of all those that we have defined, taking the furthest limit of a particular chemical of concern and then just superimposing over each so we get a boundary. So we have defined the limit by having wells outside what's called the protective concentration level, which TCQ has for a drinking water route of exposure.
So you've stepped out to find.
We stepped out to find it, yes.
The boundary, that's the short answer.
And also, as far as the soil goes, all the soil contamination is confined to the property. Thank you. Thank you.
Councilman?
Yeah, I was just going to ask, actually a question for a city attorney. If the council were to approve this designation, would that approval in any way mitigate the neighbors if there's any legal action or any other recourse or anything went down the line, or would it prevent them from getting additional testing as necessary so they would feel better about the likelihood of this encroaching on their properties more?
It wouldn't prevent them from getting additional testing, but I'm not sure I understand your question about mitigation.
Well, I was just saying, if we were to grant this designation, would anything in granting this designation prevent our citizenry from being able to get any kind of legal recourse should it come to that, or require have additional testing done?
I have not researched that issue, and it would probably be a private legal dispute, so I cannot give you an answer on that tonight.
Okay, so we're not sure of that then, because that would be
I don't know
my
if
only
statute of
concern.
limitations have passed or what the facts are surrounding all of this issue.
I can address it, I mean, to the extent that if the question is, does this in any affect any rights they might have, the answer is no. This is just a deed restriction on PSC's own property. It would affect future owners of that 71 acres, say you can't put a groundwater well in, but if they wanted to go to TCEQ and see the records and ask questions, they're free to do that, and this has no impact on that at all.
So it's a property, it's a property deed restriction.
It is.
It's a restriction on that property. It's not giving a pass that in terms of
Not
saying
at
you
all.
cannot, you don't have to remediate the condition. It's just saying that on this property you cannot drill
Correct.
a well.
So again, so it doesn't convey any additional rights or limited liability to the property owner should this designation be granted?
No, it only affects anyone who owns the property now or in the future from trying to drink the water. That is the only
Or you
thing.
can't drill wells, which the safety part I like. I
Yes.
just want to be sure about, from what I heard, that it doesn't take away our citizens' rights there.
That's
All right,
correct.
thank you.
You're welcome.
Councilman?
Thank you, Mr. Mayor. I have a trio of questions that I've been thinking about for whoever wants to field them. The first, it seems like this is a very old issue, and I'm wondering why this request for a municipal setting designation came up now. Secondly, I can see the benefit to the applicant, and I don't want to be unreasonable to the applicant, but I would like to understand what the benefit to the city or the residents is of supporting the municipal setting designation. And then thirdly, what would happen if the council voted against the municipal setting designation? What effect would that have? What would that vote mean?
Okay, so why does it come up now is the first question. Of course, it was discovered, in the 2010, 11, 12 time period, and then investigations started being done, soil first, and then in groundwater. So it came up now because that is when we have found the results. So that's the timeliness of it. The benefit to the city and residential, it's a public health issue. The questions that people have here, they're different than the question we're asking you today, and their questions are understandable. The question here is, can we restrict groundwater from being ingested for drinking on this property? Their questions are, am I in danger? We understand those. That is the TCEQ's realm. That the city, is all these issues are the state agency addresses those, and that's where the answer to those questions are. But the benefit is how do we know someone won't drink it? If we deny it now, then it's still going to be there, and someone could access it in the future. It doesn't help to deny it. It doesn't help the issues of which people, understandably are concerned. It's hard to argue we shouldn't try to protect people if we know something is there and there's a way to do it that the state law allows. The third was council. What was? Maybe
I think you answered all three.
You answered all
3 for 3. Thank you, and
Yes,
I
thank
do have
you.
more questions.
I have and I empathize with the homeowners and the discussion and the questions they brought up. The question that I have is placing a boundary around it. I totally understand, in that we're basically saying you're not going to drill here and you're not going to bring the water that's below ground up to the surface, period, which then could contaminate the upper layers of the soil and could get into the drinking system through streams and everything else. Understand that. The question that I have is, does this allow mitigation and remediation of the soil and the contaminants to go forward? And who's going to do it and when they're going to do it?
Yes, this is just a part of the process. all of the other media, if it's impacted, has to be addressed. The laws are very clear. The TCQ has put out in their Texas risk reduction rules. So it's sometimes some of them are as simple as a lookup table. You know, if it's this, you have to do that, and that's what the process is in. The TCEQ is the ultimate decider of what happens. If it's of certain levels and a background concentration, it can stay there. If it's capped and there's no exposure, they may make one decision or another. They take all that information and the data, and they come up with the final plan. Here's what you must do under the law. And as to who will do that, Dell had the property. They're the ones that put it in the voluntary cleanup program. They have since sold it, but they have agreed to finish it through to fruition. And so when the TCQ gets all the data, that's when the decisions get made. And so I think Dell is a well-known company. Understandably was concerned itself when it realized its office building was the subject of source area of historical impacts, and it stepped up and it put it in the program, and it is cleaning up things it had nothing to do with as well. So I mean, I think that's a proactive and good thing. What you don't want is people running away saying, not mine, not mine. You know, if you have it and you're on it, deal with it. And so that is the process, though.
And I had one other question from your statement that you were saying, and I agree with you that Dell and PSC is certainly making a proactive stance on this. But do we know at any timetable at this point in time that TCEQ would come forward and say, this is when it's going to be done?
We have been turning in monthly reports, giving data. It is our, I think, sense within 6 to 12 months, they would have had a chance to look at all the data and work out a solution. Paul, am I in the correct time frame there?
More or less.
More
yes.
or less. I mean, that's what we believe. Once they have all the data, and we would ask them to do it, because the other thing is Dell doesn't own the property anymore, and so we would like to resolve it as well.
Thank you.
Thank you.
Council, do we have any further questions? If not, we'll entertain a motion. Public
Yes,
hearing
I
is
have.
closed.
Well,
Let's
I
just
further,
start.
I'm
Yeah.
sorry.
No, I was speaking to the gentleman here. Go ahead.
Oh, okay. My apologies.
Go. Excuse me, the public hearing is closed. Thank you.
So my questions center around understanding the effect of the municipal setting designation, and I guess what my last set of questions was aimed at was, does granting this municipal setting designation affect whether and when any ultimate cleanup of these contaminants would occur? And I don't know whether that would occur or not, but is that a decision to be made by the TCEQ, and does any action we take tonight make that more or less likely?
No, I don't think it affects the TCEQ's remediation program as it looks at the data and their timing. In many cases, it has expedited things because people want to get the program done, and they have applied for it. I mean, it draws the TCEQ's attention to it. They're not always the most prompt in responding to things, and when we put these in front of them, they have to deal with it. They have a time frame in the statute. Once we give this to them, they have to act within 60 or 90 days. So we've regarded that as a favorable thing, because we have been asking them to expedite their attention to the site and let's move on and finish it up.
And just to further elaborate on that question, I think the concern is that if we were to grant a municipal setting designation, that it is, essentially like what we do with nuclear waste. You put it down somewhere and you say, well, a few million years from now, that'll be okay, and you kind of cordon off the area. Is that what we're doing here? Just saying, well, this is contaminated, let's cordon it off and not do anything about that? Or is the decision to have a cleanup or not have a cleanup made independent of whether the municipal setting designation is granted?
It doesn't affect, groundwater has to be dealt with. The only difference is do you have to use your science to restore it to drinking water so that people can drink it. If it's exposed to people or the environment or getting out in streams, it has to be addressed. And so the issue there is just, do you have to restore it so people can drink it? And what the legislature said in their law was, well, if you're on city water, and I guess people here have observed, you're never going to put a well in, you're never going to drink it. We don't have to deal with that issue. It's not on the table in front of us, but it's not a pass. Groundwater, soil, any impacts on the property, the TCEQ has to imply the program in conjunction with the program they have. The laws have to be met, so there's no pass.
Okay, and so just to further clarify, if we were to grant the municipal setting designation, and what I thought I heard you say was that if we grant the municipal setting designation, then there would still be some cleanup, potentially some cleanup of the contaminants, but it would obviate the requirement that the applicant or whoever is responsible for the cleanup restore the water to drinking water quality. It would be some lower standard than that?
Not exactly. What it is that if you're on city water, you don't have to make it drinkable for people that might pull it out of this property. So the problem with that is, like as someone observed, is it brackish? Is it drinkable even in its natural state? You don't know. And then the time it takes to, spend 20, 100 years to try to decide whether it can be drinkable is an issue. But it does, what the TCEQ says and what the state says is, you have to deal with groundwater. If it's above our levels, if it's at certain levels, it's going to have to be dealt with. If it's exposed to people, it's going to have to be dealt with. So it is not a pass on groundwater, soil, or other media.
Okay, but perhaps I'm just dense, but I remain unclear on whether the municipal setting designation changes the standards for any potential cleanup. If we were to vote no tonight, does that mean that TCEQ could then say you have to restore this to drinking water quality, whereas if we vote yes, then they might not? Or I'm just trying to understand the effect of tonight's vote.
Sure, it's ultimately all of that's up to TCEQ. The issue of whether they want it to people to try to restore it to drinking water quality is up to them. Whether it can be restored to drinking water quality is a technical issue. It's up to them.
But it's irrespective of this designation.
That's exactly
I think that's
right.
what he's trying
Absolutely.
to find. So regardless of the designation, the commission will say the quality that they want the water. Again, what's before us is a decision as to whether someone can drill a well on this property or not. And whether, if we say yes, if we say no, if we give this designation, we're saying, no, you cannot drill a well here. And the TCEQ will still say, here's the standards that you have to remediate to. And if we deny this, then we're allowing someone to potentially drill a well there. And the TCEQ will still say, here's the level of quality the water has to get to.
Yes, it's ultimately TCEQ will decide, yes.
Yes.
And what I just want to make sure of is obviously I'm in favor of the part where we don't want people drilling wells into contaminated water. I mean, that makes complete sense. I'm just trying to get 100% assurance that nothing we're doing tonight is letting anyone off the hook or even lowering the standard for a response to this contamination, that the only effect of a yes vote would be to say you can't drill on this water. And that no, because I very much sympathize. I would not want water to be left in my neighborhood and just say, well, it's 40 feet below ground, so we'll just leave that contaminated. It may be, but I wouldn't want that, and that doesn't strike me as a city of excellence move. So certainly saying don't drill into contaminated water. I mean, that seems like an obvious choice, but I just want assurance that nobody is getting a pass as a result of anything we might do tonight.
No, you still have to do all the cleanup obligations that TCEQ has in its program.
Well, and I guess, I don't mean to belabor the point, but when you say all of the obligations that TCEQ has in its program, what I understood from the materials we were given was that if we pass a resolution supporting the application to TCEQ for a municipal setting designation, that is a prerequisite to TCEQ granting the municipal setting designation. So what I'm wondering is if we do that and TCEQ grants that municipal setting designation, which as I understand it, they can't do without our yes vote tonight, then does that have any impact on how TCEQ ultimately resolves this contamination?
The impact, the thing they can do, if you can show them that no one is drinking, if you're on city water, they can say, we won't make you try to make it drinkable in the future. But if the water is impacted and it's exposed, it's getting out, there's a vapor, all those regulations are still there. It's not a pass.
Right.
Let me state it another way, because I think I know what you're getting at. If we pass this ordinance that's in the next item, assuring TCEQ that we have a regulation that this will never become drinking water, does that change what they may require you to do? If you didn't have the ordinance, might you have to do something different?
I think it is possible that if they thought the water could ever be drinkable and anybody wanted to drink it, they could say, pump and treat it for 100 years to make it drinkable. It's possible. It's not likely. In Houston, we had one where the technology it would take 600 years of treatment. That is part of the reason why the law is there. It's not going to be drinkable. So the answer is the state said, if you show you're not drinking it, the TCEQ doesn't have to make it drinkable, nor did they ever have to, and nor can every property be made drinkable.
Excuse me, sir. The public hearing is closed, and I would respectfully ask you. Sir, can you have him stop? Please. Thank you. Public hearing is closed. Thank you. The public hearing is closed. Thank you. The public hearing is closed. Thank you.
I think the TCEQ, the questions that they have are not necessarily for the city of Plano. They're for the technical experts at the TCEQ. What are you doing to protect us? What's your plan going to be for the property?
Councilman, do you have any further questions?
I guess that I have further questions, but they may be moot. If I'm understanding that we may be lowering the standards for a cleanup, then even potentially to drinking water standards at some point, if that's something TCEQ might otherwise require, and we would be removing that requirement, then I don't know that this is something I can be comfortable voting for tonight. So thank you.
And I think that's unknown. That's unknown. So
well, and is that unknown? Maybe I'm just confused, but I thought
she's saying. Well, what I'm understanding is that it may not have to go to the level of drinking water, but if it does, if you had to, it could be 600 years before that would happen. From the example you shared, so it's unknown. I think what's before us is a decision as to whether we want to make sure that we say you can't drink water here, and if the standard that's being lowered is saying that they will not bring it to drinking water capacity, then that's what it is.
Let me add one thing. I think that may make it's a relevant component, which is the statutes are very clear that city can always remove its agreement, always. So, and you'd have to notify TCEQ. So anytime there is any issue, supported by data or whatever the concern is, the city can always say, we're going to pull it out. We're not comfortable with it. So you can protect, the issue now, but change your mind later under the law.
Okay, well, thank you for that clarification. Yes. And then I just have a quick question, Ms. Mims. If we were to passed the ordinance restricting drilling, but not the resolution to TCEQ, do we know what effect that would have?
The TCQ program requires the resolution.
I understand that. I guess what I was saying is you know, if we were to, obviously we don't want people drilling into contaminated water, but as far as anything that might lower the standards for cleanup, I'm concerned. You know, this feels to me like it happened, you know, for something that's been moving since 2010 or 2011. Feels like, you know, the public hearing was last week, August 8th. I don't understand the urgency of this, and I'm, you know, frankly, it felt to me like it happened very fast. So that's my concern.
Go ahead. Say that loud. I don't think.
I do not know the answer to your question, but if the council's desires to table it, we'll bring you more information on that. What I'm hearing you say is, even if we don't pass the ordinance, you may not have to take any remediating action.
No. I mean, the property has impacts, and it's in the program. We have to
do it
satisfy the TCEQ to closure, whatever the TCEQ
Right, but
requires.
you said if there's certain testing levels that don't concern them, you don't.
Well, they have
do
charts and things that say if it's under this, then you do that. If it's over this, you do that. That's all still there.
You have more?
No, not at this time.
Okay.
So, Council, can I make a quick recommendation based on the feedback of the speed of the public meeting and tonight's hearing? What I'm hearing and I'm reading at the same time as we're talking through this is there's maybe some unsurety about what TCEQ is going to require, whether an MSD is passed or not. From what I can read on this, and this is a TCEQ publication, their guide to cities. The MSD law provides an alternative to the standard TCEQ regulatory requirements. And so to me, that goes to what, council member, that you're talking about. Instead of restoring or controlling the contaminated groundwater zone so it can be used as a potable water, a prohibition is placed on the designated groundwater beneath the MSD property to prevent people from using the contaminated groundwater as potable water as a means to protect the public. When I read that, I understand what you're saying as far as we're dropping the standards if we put an MSD on it. What I think the applicant is saying, and she probably has more experience than I do, we've only done one in the city of Plano, and that was 2008 before I arrived, is TCEQ may come back and say, you have public water, North Texas Municipal Water District provides public water to this site, clean water, that we are not going to require you to meet the potable requirements for the groundwater in this area. You still are required to remediate it because they have self-identified they're part of the cleanup program. They still have to do that. But I think what the applicant is saying is you may not have to do it regardless of an MSD or not that's on there. My recommendation, again, is what you had talked about, would be to table this and bring it up at the next meeting, get that clear, and proceed with that.
Well, thank you for that information, Mr. Thornhill, and that was the direction I was leaning anyway. So, if I might make a motion.
Please.
Thank you. And I do apologize for the 99 questions, but it was just, you know, I myself was confused, so I can understand how residents are confused. I read the whole packet and came out a bit confused. So without further ado, I move to table this item until our next meeting on August 28th.
Mr. Mayor, I would like to second that motion. I'd like to add a caveat on that somebody from TCEQ be here.
Yes, that would be very helpful.
Can we? I don't know. We can require.
Well, I guess we can't. Yeah.
I don't know. We can require them to be here, but certainly get us all the information.
Ask them nicely. Yeah.
Get us all the information, obviously, in order to make the decision. We have a motion and a second. Any further comment? Please vote. And the item is, the motion to table item 1 has passed 7-0.